The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
Good morning and welcome back. It's Court Radio and I'm Dean Weitzman. And you're listening to your hour where you can ask any legal question you have, make any comment about the crazy government we have, whatever floats your boat. All you got to do is give us a call at 215-227-2727. That number from 7 to 8 on Sunday mornings is your beloved Court Radio. And the rest of the week, it's My Philly Lawyer, 215-227-2727. An appropriate explosion. And I know he's just itching to start talking. He's the one and only. You know him, folks. He's here when we're talking about work-related injuries. Jeff Gross.
Good morning.
Welcome back, Jeffrey.
Thank you.
My pleasure. You know, I don't know. Let's see what's in the news. Do you have any pet peeves, Jeffrey?
Yes. Big time.
Really?
Yes.
Well, give me one of your pet peeves.
The far right.
The far right? I see. On the political spectrum.
Yes, of course.
Uh-huh. Yeah, it seems like we're electing people that are going to try to roll back the clock, the sands of time.
Yes, and the cold weather.
Cold weather's a pet peeve.
Oh, yeah.
Really?
The colder, the worse.
The colder, the worse. I look forward to each season. I embrace each season for what it has to offer us.
Yeah, for the first 2 weeks.
Yeah, right. Well, then I'm on a plane to South Beach or somewhere.
Exactly.
You know? Pet peeves. I don't like when people spit. Yeah.
Usually you can get fined in the city for spitting, you know.
Public spitting is just the worst thing. I mean, I would arrest and incarcerate public spitters. And then all those other people who, you know, just got loaded too much and you know, were like publicly drunk, I would release them and just put the spitters in jail.
Well, if it evaporates, then it's no harm, no foul.
It never evaporates. These are naturally phlegmy people. They're phlegmsters.
I'll bet you your listeners really love hearing the descriptive terms of that this early in the morning.
But that, as you said, and how we're going to dovetail it, is that it is a crime.
Well, you know what could happen if there's too much spit on the ground, don't you?
You'd slip.
You'd slip.
And fall.
And fall.
And injure yourself.
Which is why they'd have to call you.
Right. And besides which, as the spitter, you don't want your DNA to be so easily available. Like, I step on your DNA, walk into a crime scene, boom, you're there. You're in the crime scene.
That's true.
You got to explain why you didn't commit the crime because your DNA was there.
You could become a suspect.
215-227-2727. Please make us stop talking about pet peeves because we want to answer your legal question. You know, Jeff, when you're here, we have to address people's concerns about their work-related injuries. You know how many people do not pursue claims that are valid, that they've been injured, that they're struggling every day to get to work because they're afraid to lose their job.
Yes, too many of my clients come to me and the very first thing they say is, well, will I lose my job if I make this claim? And they're afraid to even assert their own inalienable rights. And the problem is that if they don't do something early, and early is key, then there's a problem. You must give notice to your employer within the first 120 days of the injury, but that's not really the standard. The standard is immediately. So even though the law says 120 days, the judges look at the person who's testifying and says, why did you wait so long?
But don't the judges understand that folks have this fear that if they assert their right, that they'll be canned?
Well, that's an interesting question, Dean, and here's the answer. The reason the judges think that people do not notify their employers quickly is because the injury is not that significant. If an injury is really significant, causing disability, which is one of the things that we have as our burden of proof to prove that you are disabled, you have to notify your employer. So if it's really that bad and you're disabled, you would notify your employer immediately.
I get it. Okay, so they're not doubting that the accident happened, but they're just doubting whether that accident was sufficient enough to have caused a disability.
Correct.
And that makes sense. So, folks, if you've been involved in an injury at work and you think that this injury is going to prevent you from engaging in your normal activities, you really have to let somebody know immediately. The question is who and how do you let them know? Folks, if you've got questions about work-related injuries, you want to talk to Jeff or myself, all you got to do is give us a call at 215-227-2727. Go ahead.
Let me answer that real quickly.
Mm-hmm.
The rule is that you must notify your supervisor or someone who is supervisory to you about the work injury. Telling a co-employee is not sufficient because if a co-employee is not superior to you, the co-employee has no duty to make that claim or push it forward any further than it already is. So if that co-employee is sitting next to you, and he doesn't want to, or he or she doesn't want to go further with it, nothing's going to happen. Okay, so if someone's supervisory to you, that would be sufficient. And there's an exception to what's called the hearsay rule, that you can actually testify in court about what someone who is superior to you says in return once you tell them. Normally you can't do that because that's considered hearsay. You can't say what another person said out of court. That's not within the ambit of the court. So this is an exception to that rule.
Interesting. Okay, so we know you have to tell a supervisor. What is it you need to tell them?
You need to explain to them what happened to you, and you need to explain to him or her what is wrong in terms of what you cannot do in connection with your job. Telling a person that you got hurt, but not telling your supervisor that you are having problems doing your job is not sufficient either. So you really want to make sure you tell them those two things, that you've gotten hurt at work and that you are unable to perform your job.
And what's the best method to convey that information?
Well, I mean, look, no one needs to always resort to writing, which is the implication that you're saying. People would always think, I better put this in writing. Well, that's good. There's nothing wrong with putting it in writing, but it doesn't necessarily need to be put in writing. The key would be to follow up. So once you notify your supervisor, they have an obligation. The burden then shifts a little bit to them for them to provide you with a list of panel physicians of the employer in order to get treatment. And that's an interesting topic in and of itself.
And one we're going to touch on. But what's a panel physician?
So under the Workers' Compensation Act, the employer is given an opportunity to have 6 panel providers comprised of doctors, coordinated care organizations, specialists of different varieties in order to treat various and sundry work-related injuries. So when you notify your supervisor that you have a work-related injury, your supervisor has an obligation to give you this list. If the employer fails to have a list, that's not bad, that's good, because that means you get to treat with any doctor of your choice. On the other hand, if there is a list, you must treat with a provider panel doctor on that list for the first 90 days. And here's the key, provided that you have signed a form when you were first employed by this employer that you were aware of such a list, and when you get injured that you sign that very same form showing that you were given that list to treat with.
Really? Wow, that is shocking to me because I don't think hardly anybody has to have signed this panel doctor list when they got the job in the first instance.
Exactly. And who knows about that rule?
You.
Me.
Oh, and only you.
Right, my staff. And I think you and your staff.
Wow. So if you didn't sign a list, this is really important. If you didn't sign a list naming the doctors that you should see when you're injured at work, then you can see any doctor you want. And here's why it's important.
Here's why it's important, because any doctor is any doctor, and any doctor can be good or bad. Let me tell you, the panel list of employer-provided panel physicians are not going to be doing this for your benefit. They're going to be doing this because they were handpicked, kind of like a cabinet, by the employer. So the employer's panel physicians are going to be somewhat biased toward that employer, since that employer has handpicked them and would like to stay on that panel. So they have this kind of, should we say, affinity towards helping the employer. So if there's a choice between the panel doctors saying that you're disabled or not disabled, take a guess on what do you think that panel physician is going to want to do.
Exactly. You know, and so, and it's, you know, the panel physicians have an affinity for themselves. They're going to keep getting their pocket lined by remaining on this physician's list if they send people back to work, regardless as to whether they're truly disabled or not.
Correct. And that's the problem. Now, they're very smart. They're not that dumb. So initially, what they're going to want to do is acknowledge the work injury and treat you, because the longer they treat you, the more money they make, you understand? And therefore, if they keep you in a light duty or your regular duty position, but say, hey, you need treatment, we're going to give you what we call shake and bake modalities, which are heat and electrical stimulation, maybe some massage, give you some medication, nothing too extravagant or expensive, but allow that to multiply in terms of revenue and bills. That's what they do, and they keep you at work, and it satisfies the employer. So,
for 89 days, because something happens on the 90th day that miraculously, the vast majority of employees are cured, like somebody laid hands on you on day 89.
That's exactly right.
Why? What happens?
What happens? They just are automatically recovered, but they don't usually do it until day 89 because they don't want to look too suspicious. They'll do it close to that time. But I have several that have gone to day 89, and I'm not kidding you. What happens after day 90 is that the claim is bought. Normally, within the first 21 days of the work injury, the employer has an obligation also of filing a bureau document with Harrisburg, which is the state capital, in case you forgot. And they must file either a notice of compensation payable or a notice of compensation denial within the first 21 days. And guess what? If they fail to file that form within the first 21 days and there's a work-related injury, they're in violation of the law. And you can actually get penalties under a specific case called Lemansky. And you can get penalties over and above your right and entitlement to workers' compensation for their failure to file the proper forms. If they file a notice of compensation denial straight out, then you can treat anywhere you want. You don't have to go for any doctor for 90 days. However, there are two forms of the notice of compensation payable, which is the acceptance form for the injury. One is a notice of temporary compensation payable, which is the usual norm, and the other is the notice of compensation payable, which is a carte blanche. Here you go, you're disabled, you're injured, we're going to accept liability for this. The notice of temporary compensation payable, guess what? Lasts for 90 days. So after 90 days, if that panel doctor continues to treat you,
it converts?
It converts, which means that's an accepted injury. It's like a first down.
It's like a first down.
Yeah, conversion.
Uh-huh.
Got it?
Yeah, got it.
Then you you extend your game of workers' compensation, basically.
Well, there's a lot of issues here that you've packed in a short time. We're going to come back to them, but we're going to take some calls. Let's talk to Ernest from Northeast Philly. Ernest.
Hey, how you doing?
Welcome to Court Radio. How are you?
I'm feeling great this morning, guys.
Thank you. Thank you for calling us. Thanks for sharing your life with us for these few minutes, Ernest.
with my question?
Yep, I'm looking for
Okay.
that. I'm looking for that question.
All right. I'm a grandfather. My daughter had passed away in 2007. And she had
By
my
the way,
granddaughter.
Ernest, I'm old enough to be a grandfather, but I'm really just a father.
Okay.
And I say that because yesterday yesterday was my 3-year-old's birthday, and Sophia and all her friends celebrated it at Chuck E. Cheese. And I've never been to a Chuck E. Cheese in 54 years, and I hope I never go back again.
It's a madhouse.
And they do have good pizza.
There's a madhouse in there.
Yeah.
I got a daughter named Sophia, too.
Okay.
That's it. We was talking all along. Let me tell you. What happened is that she left some money from a job, $60,000. So I'm looking. It wasn't in nobody's name because she was only 22 years old when she passed away. So the father came along, and my mom told him about the money. He wouldn't got the money. So he was collecting on Social Security. We haven't heard from this guy in 5 months now. He never really gave that much money. He was just, what they call, he's the proxy. What he became, I don't know what you say.
No, not the proxy. It's the administrator or executor.
Okay.
So
anyway,
this is you're talking about the father of this 22-year-old decedent.
No, the father of the granddaughter. He's the granddaughter's father.
He's the granddaughter. Okay.
Yeah, he's my granddaughter's father.
So if there's let me just say this, Ernest. If there's, I assume your daughter did not leave a will.
Oh, she did not.
Okay. And so, without a will, her property passes to her next of kin, which would be her child.
Right.
Okay. And how old's the child?
Makias right now she's 12.
Okay. And so in order for him to handle this money, he has to get court permission to accept it, and then he has to put it into an account for your granddaughter's benefit for when she turns 18. Now, you could check on all that. You could check on all that by going down to City Hall. I assume your daughter passed in Philadelphia County?
Right.
Yeah.
But no, just understand the question. I'm saying we're trying to get the money from him. He's getting the money. He's been getting it, but he been getting penny pinching, disappearing. That ain't disappeared for 4 months.
Yeah, well, here's what you can do. If he's not doing what he needs to do to protect the money of his child, your granddaughter, you can report that to the court and ask them to replace him as bringing in another administrator, another executor to handle the finances for your daughter. And what I would do you know where the money's coming from?
It was left from her job, $60,000 from her job.
Okay, it may have been just one lump sum payment to him of $60,000, and in that case, the job really isn't going to be able to stop that if it's already happened. But again, you can ask the court to replace him, and also to ask the court to force him to tell you what happened with the money. It's called an accounting. You can demand an accounting from him as the administrator of your daughter's estate.
Wow, because that money supposed to have been for my granddaughter.
It absolutely. Let me just double check one thing. He and your daughter, the father and your daughter, were not legally married. Is that correct?
Absolutely not. That's right.
Okay. So if they're not legally married, then that property is 100% the property of your granddaughter. Unless, okay, there's always an unless in the law, unless your daughter listed the father of her child as the beneficiary of that funds. So if she did not, okay. So if she didn't list him as her beneficiary and they're not married, then that is 100%. Now I can say it with absolute certainty. That's 100% the property of your daughter, of your granddaughter. And
He's been pitching it. He's been going in the money now.
Yeah.
I wonder if he cleaned it all up.
well, it's possible he has, but then he'd owe it back, and you could get a judgment against him. But in the first instance, I would go down to City Hall, and I would file for an accounting. Now, the problem is that this is complicated stuff, and you're going to have to do this on your own because if you retain private counsel, they're going to charge you fees just to file these papers. And if there aren't funds to pay private counsel, then it's something that you're going to have to try to do on your own by going down there and talking to the court personnel and voicing your concerns and letting them know that and see if they'll file for an accounting for you.
Okay, because she's been living with my grandmother ever since my daughter passed away. She never lived with this guy. My mother was taking him to school, had to get insurance for everything. He hasn't done absolutely nothing.
Hey, Ernest, this is Jeff Gross. You may want to go down to Community Legal Services on behalf of your granddaughter. And do that. They'll help you because your granddaughter can't afford. It's going to be her money, right?
Yeah, it's supposed to be.
Yeah, so she's not going to be able to afford legal counsel. And if you're going down on her behalf,
and
they may
here's
be able to help you.
one last thing, and then we got to run, Ernest.
Okay.
I don't understand how he would have gotten that money in the first instance if he can't prove he's married to your daughter and he wasn't listed as a beneficiary. Then the employer had no ability to hand him your granddaughter's money without court permission. If he didn't get the appropriate court permission and the job gave away the money, I think there's a claim against the job to replace that money. So you may not be out of luck here. You may not be chasing ghosts. You actually may have a legitimate insurance company and or employer to get this money paid back.
Because they was asking for, I was trying to get the money, but they said, is the father living? I said, he is. So another said the father's living. He went down there. And the money was just saved for her when she got 18. That's the bottom line.
I like I said, you very well may have a bona fide claim against the employer if they handed the money over to him without court permission.
Okay, so go to legal service.
Community legal services. Yeah. Thank you, Ernest.
What the file?
Say again.
What the file again? You said file for?
Oh, an accounting. Yeah.
Okay.
All right.
Okay.
Take care. Have a great Sunday.
Hey, thank you guys, man. Love you guys.
Love you too. 215-227-2727. We have Jeff Gross in the studio, and Jeff and I have been talking about workers' compensation. Seems like the most common place for somebody to become injured.
It's pretty common.
Yeah.
A lot of people working, a lot of people getting hurt.
Yeah, and you're working, you're sleeping for 8 hours a day, you're working for 8 hours a day. So, and then you're doing all your little errands and stuff on the other 8, but that's kind of safe because you're usually just sitting there eating or something during the off 8.
Which reminds me that a lot of people get hurt at work and don't even realize that they're hurt at work and it's a work-related injury. For instance.
You're going to give me the butcher.
Not the butcher.
Candlestick maker?
Not the candlestick maker. But if I employ somebody and I need them to run an errand for me, and they go out and they get hurt, or if they get into an accident, or if they simply aren't given an errand to run and they go out for a momentary deviation of their employment and they get hurt, that's considered a work injury.
Yeah, I think most people would realize that. You don't think they would realize that?
Some people don't get it. Some people think that. I had one woman who was a daycare worker. She worked for 3 different daycare offices. And she was traveling from one to the other, and she got rear-ended and gotten really badly hurt. And she went to a friend of mine who referred the case to me, and my friend said, what were you doing? And she said, I was driving between one daycare center and another. And he said, well, weren't you in the course and scope of your employment? And she said, no, I was driving my own car. And she didn't realize.
Okay. And you know what? But I thought you were going in a different direction, so I'm just going to lay it out there about the repetitive tasks that we engage in that may, over time, create a degenerative condition. And, I know a lot of people who are in, let's say, the construction business, hammering nails all day, or at least they did before they had nail guns, and they'd get carpal tunnel syndrome in their hands and have to go out for surgery. And because they don't have health benefits or time off, they ate all that.
Right. And in fact, many people think that they don't, if your employer doesn't give you health benefits and you get hurt at work, that you're not entitled to do anything because you don't have any health benefits. Health benefits and workers' compensation benefits are two different animals. Workers' compensation covers anyone who is working in the Commonwealth of Pennsylvania and gets hurt. Doesn't matter if your employer gives you health benefits or not.
Let's take it for instance. Here we have our little producer, Eric. Okay.
A good man.
Yeah, a good man.
He looks very, very cool.
He's tired today, though. So Eric has headphones on because that's his job. And let's say over time he goes deaf, can't hear. I mean, and it's kind of hard to be a producer and be deaf. Would his slow hearing loss, because he's listening to me so loudly, so closely, he can't escape from my voice, would that be a work-related injury?
Well, it would have to be proven that his hearing loss were directly caused by whatever he's listening to. And if you keep screaming at him, then yeah, definitely that might be considered a work-related injury. And the rule with hearing loss, in case anyone out there has hearing loss and can't hear what I'm saying, you have to suffer 10% binaural hearing loss. That means in both ears. But yes, that could be considered work-related. And the rule is if you get hurt at work and you stop working because of the condition, you have to bring a claim within 3 years of the date of last exposure to the problem.
Okay. So like every case, folks, has a statute of limitations, and in personal injury, you're typically going to be faced with a 2-year statute of limitations. Medical malpractice, 2-year statute of limitations. But as Jeff just explained, on workers' compensation claims, 3-year statute of limitations.
And people don't realize that the date of last work equals the date of last exposure, which is the date of accident in determining the statute of limitations. Many people do the same thing over and over again, like rotate their arm, or like you said, typing, somebody who's typing a lot and gets carpal tunnel syndrome. And you can't, and then, let's say the condition comes on in June and you stop working in December. Okay, the date of injury is not in June. The date of injury is in June and in July and in August and in September and so forth until you last work. Remember, every day that you work is an insult to the condition. Therefore, the date you last work is the date of accident for purposes of determining the statute of limitations.
Cool. 215-227-2727. Let's talk to Diamond from North Philly. Good morning, Diamond.
Good morning.
How are you this morning?
I'm doing pretty good, and yourself?
Good. Are you going to be running in the Philadelphia Marathon today?
Oh, no. I'm just getting off work.
Okay. Well, there is a marathon today, and streets are being closed all over the place.
And that's why I'm staying in.
There you go. What's your question, Diamond from North Philly?
I actually went through a workman's comp case early this year, and around the beginning of April, I hurt my back at work assisting a patient. So I went out on workman's comp for a while, but they only let me go up to, I believe, April, May, June. And I believe the end of June or maybe like July-ish, they told me that I was okay. And I'm trying to tell them I might walk okay because it's on and off. But at nighttime, my back really hurts. And every time I go to the therapy, the day after, it's horrible. It's a downhill every time I go to therapy. So we assure you you're going to be okay, blah, blah, blah. And I just overheard you speaking about the, I think, 89th day rule. So I'm that rang a bell. So I'm let me call in and see, what I can make of this.
Diamond, this is Jeff Gross. I have a couple questions for you.
Sure.
You're still having problems now?
Yes.
Okay. And it's been way beyond 90 days, right?
Correct.
So you don't have to go to that doctor anymore. You can go anywhere you want. Are you still getting treatment from any doctor now?
No, that's the thing. Once they took me off I had to stop going to the doctor. They took me off the workman's comp, and they put me back on active duty. But once I was on active duty, they never gave me any other assignments.
Right. So
I ended up having to find another source of income.
All right. So are you working in any capacity right now?
Yes.
What are you doing now? Without telling me who your employer is.
Oh, I'm doing CNA work.
You're doing what?
CNA work.
Okay, so
I work in a facility.
are you having trouble with that? Or are you okay with that?
I'm okay with it because, like I said, usually, like in the daytime, I'm okay. It's once I wind down and I get in a relaxed state, that's when it like hits me.
All right, so your original employer is still responsible for this injury. So if you're still having trouble with your problem, you should go back to that doctor or go to your own doctor or come and see me, and I'll get you to somebody who can help you.
Oh, that would be great.
So the key is that she's not able to perform her job duties. Does that mean, and as she explains, I do it, but then at the end of the day, I'm in a lot of pain.
Right, and the only way to properly bring a claim like that is to be able to prove that that's the case, and the only way to do that is to have it documented. So you should continue to go to a doctor because your failure to go to a doctor will be looked upon as your inability to prove that you have an ongoing problem. There's going to be a gap in treatment, and gaps in treatment looked upon by the judges very disfavorably. So I think you should continue to go see a doctor. You have a primary care physician?
Yes, I do.
Go to that primary care physician, give me a call, and I can help you further.
All right. Thank you. Do I get your number off the record or?
No, you call that number, you call that same number, 215-227-2727. It's the number that everybody calls when they have a legal issue all week long. It's My Philly Lawyer, and Jeff will be happy to schedule you by calling that number.
Thank you, Diamond.
Diamond.
Diamond. Yeah. I said Diamond.
Yeah. No, I know. She's...
not Ruby.
Bye-bye. Thank you. Folks, we'll be back in 2 minutes after my sponsors have their way with you.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. It's still Court Radio. I'm still Dean Weitzman. And this is your hour to ask whatever legal questions you have. We are joined in studio with my friend and colleague, Jeffrey Gross.
Good morning. So while we were off the air, we started talking about an issue called concurrent employment.
Yeah, because, and I was saying, nowadays it's so common for folks to need to have 2, 3, or more jobs in order to pay the bills because, minimum wage is not cutting it any longer.
And people's families are growing.
And so, with multiple jobs, you're injured at a job. What happens in that circumstance?
So, the time of injury employer, meaning the employer that you are with when you have your injury, is responsible for your injury at work as well as any concurrent, meaning other jobs that you happen to be working at the same time for your injury. So, for instance, you're working...
Wait, hold that for instance.
All right.
Because we have a for instance, a real live one.
Okay.
Let's talk to Joe on line 4. Hello,
hey.
Joe. Joe, good morning.
Can you hear me?
I can hear you loud and clear. How are you?
Great. I'm doing great. Morning, Dean and Jeff. I got a question. I work 2 jobs. Got hurt on the first job. My first job is saying if I go to work at my second job that I would be fired or to have problems because I shouldn't be able to work a second job if I got hurt on the first job. How am I able to do both of them? Even though my duties are kind of different. First job, I'm driving. Second job, I'm really kind of just sitting around shuffling paperwork, sending off emails. What do you guys think?
So, your first job is responsible for both your first and your second job. If you can work your second job, you have what we call a partial disability as opposed to a total disability. And it's okay for you to work your second job. the good news is that you get to combine your average weekly wage from both jobs in determining your compensation benefit rate.
As long as he's not working that second job.
Well, no, even if he's working that second job,
Oh, wow.
the calculation of the benefit rate is the combined first job, second job wages. So you're entitled to 2/3 of your gross average weekly wage to the extent of your disability. So the higher the average weekly wage, the higher the benefit rate, obviously. And if you work another job, that's going to add to your benefit. Now, if you cannot work your second job, you will have an even higher rate. You'll have the full amount of your 2/3 of your gross average weekly wage. But if you're able to work your second job or a portion thereof and you're getting a differential, you'll still get a partial disability from the second job. So I don't know what your job is. You said you're sitting around all day. It's a sedentary type of job. Is that right?
Yeah.
All right. So you're entitled to the first job, but at the rate of the total. So believe me, if you're working one job and one job only, you're going to get 2/3 of that job, but the second job will increase the value, and there's a mathematical difference in the first and the second. So you want to make sure that you report the working of the second job and that you had been working there at the time of the original injury to the insurance carrier, because if you don't, what they will do is they will think that you are doing a double dip, which is collecting workers' comp and working at the same time, and that is a no-no, unless, of course, you report it and it exists as of the date of injury. You understand that?
I understand. It was a lot, but yeah, I get what you're saying.
If you have questions, though, please call me. I'll go over all this with you, and I'll make sure you're set straight.
Wow. Thanks, Jeff. Thanks, Dean.
Hey, Joe, I want you to stay on the line, bro, and I want to get you a T-shirt for Court Radio. Wear it often, wear it proud.
It's my wife's birthday. It's going to her.
All right. Stay on the line. Monica will get your contact info.
Thanks.
All right. 215-227-2727. Let's talk to Lewis from Chester on line 1. Hey, Lewis, welcome to Court Radio.
Thank you.
My pleasure.
I just called to let you know that Jeffrey Gross handled a case for me a few years ago, and I just want to give him his due. They helped me a lot. You know what I'm saying?
Thank you, Lewis.
I appreciate that.
Did you plan this, Jeff?
I believe.
I did not plan this.
No. I know he didn't plan that. I listened to Court Radio.
Oh, Lewis, thank you so much.
You remember, I'm not going to say I was working for a casino. I ain't going to call it a casino name, but
I know Lewis.
Yes.
Lewis is a good man.
Yeah, so Jeff, I want any of the listeners, and I'm not trying to. I'm just telling the truth.
There you go.
If they want a workman's comp lawyer, attorney, whatever, they need to get in touch with you.
That's very nice of you, Lewis. I really appreciate it.
For real.
All right.
I'm keeping it real. Okay.
Lewis,
that's all I want to say.
Thank you so much for your kind words to Jeff. You know, he's the only attorney I know, okay, who actually hands out his cell phone to every client. Crazy.
You're right about that. I'm sorry to cut you off, but that's the exact God's heaven truth. And too many attorneys don't do that.
Yes, sir.
Yeah, well, when you're my client, you're my family, and I
know that's right, Jeff.
I treat you that way.
Right.
All right, Lewis, have a great day. Thanks for calling Court Radio.
And thank you, guys. Okay.
All right.
God bless you guys. Bye-bye.
Bye now. Wow. If you would just tape that, then you don't need to make a commercial anymore for Court Radio.
True. That's so nice of Lewis to call. And I remember Lewis, and I remember his lovely voice.
Yes. Yeah, he's got a good voice.
He does.
I'm wondering, what is it like when you get to use a word in your nomenclature that's your last name? So you were talking about gross weekly wages.
That was done for my benefit. It's an advertisement. Average weekly wage is one thing. Gross average weekly wage is another. So, the difference between gross and net, in case the listeners are somewhat confused, you get 2/3 of your gross average weekly wage. That means before taxes. So you don't look at what your take home is and then get 2/3 of that. You look at what your your wages are before taxes, and you get 2/3 of that. And by the way, there is no taxation, whether federal or state.
Without representation.
But there is no taxation in workers' compensation. So you can settle your case for a lump sum of money, and there is no tax on that settlement.
Because you're only getting 2/3.
That's correct. And presumably the negotiated settlement is based upon 2/3 of your gross average weekly wage itself.
Right. 215-227-2727. You've got legal questions. Jeffrey Gross and I probably have the answer. All you got to do is give us a call. Let's talk to Geraldine from Northeast Philly on line 3, Eric. Hi, Geraldine.
Good morning.
How are you?
I'm fine. I'm calling about, I had got a title loan from Delaware.
You have gotten a title, what did you say, a title loan?
Yes.
What's a title loan? Oh, you mean for a car?
Yes. You
Right.
borrow money off your car.
I got it. Okay, so you own your car, you get your title, you borrow $1,000, you send them the title, and they hold it till you pay the money back.
Exactly.
Go ahead. All right, now tell me what that.
I was late on my payment, and I took my car to a shop, and they found my car and they repoed it.
Wow. See?
And I was able to pay the amount due.
Uh-huh. Right.
And when I went for my car, they told me it was in the repo place, the garage. So by the time I went there, it was like $1,000. After that, I couldn't get it at $1,000, and it's $40 per day, and it's been 2 months, and it's tallied up to $3,000. And I'm on disability. I have on limited income. How do I go about that? Can I find a way for them to reduce the $40 per charge?
Well, yes. I mean, that's called negotiations, and perhaps you'll be able to engage in that. They also might hold a very hard line because the car's value might be enough to cover that you owe. But if it's not, then that's really where the negotiations occur. In other words, if you've got a car that's worth $1,000 and they're trying to charge you $3,000, that doesn't make a lot of sense, and they're never going to get their $3,000. They're going to only get some portion of that $1,000, which is the value of the car. So therein lies the potential for negotiations, and all of that is predicated upon my belief, but you need to check this out, okay, that these types of consequential damages are listed in the contract. So you borrowed money from a loan company, and in there it said, if you don't pay us back, we're going to repo your car. And it needs to say in there, and if we repo your car, you're going to be responsible for all of the sundry consequential damages like towing and storage and whatnot. And so if it doesn't say it in the contract, then this towing company has no contract with you and no right to charge you a nickel. So you want to make sure it's in your loan documents. Otherwise, you could turn around and sue the loan company because this guy is their agent. He's working on their behalf. And if he's in violation of your contract with the loan company, then the loan company has to make good on that. Okay?
Okay, so I have to revise my contract, which I think it spoke something of sort, but I wasn't sure.
Yeah, the contract is where these damages will have to be specified. And if they are not, then you don't owe them.
So they have to give me my car.
They have to give you your car, and you could sue the loan company, and you could sue the towing company in small claims court, and you will win so long as in the contract it is not specifically stating that you're going to have to pay towing and storage.
All right.
All right?
Thank you.
You're welcome.
Have a good day.
See, you empower people with knowledge.
Yes, empowerment is a good thing.
Right?
Especially in this climate.
Yes, especially because if you don't fight for your rights, they're going to be snatched from you.
That's right.
And contracts that are ambiguous are always decided against the maker of the contract. You're signing something, you have no control over what's in there, and if it's not specific, then you probably can get out of that obligation.
Which brings me back to the Workers' Compensation Act, which is very empowering, more empowering than people realize, because the law is on your side. It's not on the side of the employer. It's a humanitarian act. It's been around since 1916 in Pennsylvania. It's been around since around that time in the rest of the 49 states. But it is on your side. So if you have a problem, bring it to your employer's attention. Get an attorney, because failure to get an attorney is like not having the knowledge that you need in order to move forward. It's necessary to do that.
Right, but people think, hey, if I get an attorney, I'm going to have to pay him part of my salary, and then I might not have enough to live on.
Well, first of all, that's a really interesting point. Everything that we do on a contingent fee. A contingent meaning that unless we are successful with the claim, there is no fee. So if I lose your case, you pay me nothing. You pay me no costs. You pay me no fees. End of story. You're good to go. But if I take your case and you win or we settle, then my fee is not huge. It's limited to 20%. So 20% of something is better than 20% of nothing.
Or 80% of nothing.
Or
yes.
80% of nothing.
80% of nothing is still nothing.
Right. Nothing from nothing leaves nothing. So you
Let's break
have
out
something.
into song now.
Exactly.
Yeah. All right. I won't, but I could have. But I don't want to distract Eric. 215-227-2727.
Eric's looking good.
727. Eric's tired. Yeah, that's the tired face of Eric. And he's doing his utmost best. He's got one more hour after us, and then he gets to go home and go to sleep. 215-227-2727.
So we were talking about concurrent employment earlier.
Yes.
And I had a client that had 4.
Well,
yes.
Can you just hold that thought for 1 second?
I certainly can.
Because we have Lonnie, who's been patiently holding on line 1. Lonnie. Oh, I see. Yeah, I get you, Eric. We'll be there in a minute. All right, Lonnie, come on. Bring it on. Get him on here.
Guys, happy Sunday to you.
Happy Sunday to you as well. Lonnie, I'm going to break for our sponsors. Jeff's one of them, and I have to kind of show him in real time that I care about him. Okay. So
fair enough. You got to pay the bills. I understand.
So I'm going to ask you to hold on for 1 second, and we'll be right back right after the break.
Sounds great.
Folks, we'll be back in 2 minutes.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. I'm Dean Weitzman, and this is Court Radio, where we're joined today, lucky us, with Jeffrey S. Gross.
Good morning.
Mr. Gross is my go-to guy for workers' compensation claims. He's an extraordinary.
Thank you very much.
So extraordinary that there's an explosion at the end.
That's me.
I would say I really think that you do an awesome job representing people on workers' comp claims. You really understand this area of the law implicitly, and you happen to know everybody in this area of the law. I mean, there's only so many judges. Have you been before them all?
Of course. Every single one of them, they're all really good judges, and they're all on your side if I'm representing you.
Yeah, if and only if. We were talking about concurrent employment.
Yes.
And I just want to wrap this up. Folks, if you've been injured at one of your jobs, but you have multiple jobs, fear not, because if that injury prevents you from engaging in your other jobs, then the job that you're injured at has to pay you for all your jobs.
Correct, and all your medical treatment as well.
And all your medical treatment as well. So do not fear, but call 215-227-2727, where we will set you straight and protect your rights.
Thank you, sir.
Mm-hmm.
We had Lonnie on the phone. Is he still with us?
I embarrassingly have to say that Eric disposed of Lonnie.
Oh, it's a shame. But I was saying earlier that I had a client once with 4.
Wait. Lonnie, if you're listening, then give a call back, and we'll get you to talk a private conversation after the show with Jeff. Okay?
Absolutely.
There you go.
So I had a client that had 4 jobs.
Get out. Really?
And it was a woman that was working 4 jobs, and she was working around. I don't know when she slept, but she worked 4 jobs, and she worked a lot of hours, like 40 hours a week for the first job, and then like 16 hours a week on the second job, and then another 15 hours on the third job, and then 10 hours on the... I mean, I don't know when she slept. Anyway, she got hurt. She couldn't do any of those jobs, and she didn't realize that she was entitled to concurrent employment for about a year and a half, maybe a year and 3/4. And what we were able to do is retroactively have her paid the higher benefit rate plus ongoing disability into the future from the 4 jobs combined. And then at the end of her claim, after about 2.5 years, 3 years of getting benefits, we settled her work-related injury claim for a very large lump sum because it was based on the totality of the employment loss.
Mr. Gross?
Yes.
We have Lonnie back on the line.
Lonnie, welcome back.
Hey, it's a lot. I lost the cell phone signal.
No worries. What was your question?
My question is, I work for a major municipality, and my coworkers and I have been entangled in a lengthy contractual dispute with the work site where they have not honored tools, equipment, supplies, uniforms, training, and contractual compensation. So my question is there any legal step that I could take fighting form union to fight the municipality?
You are a union member, correct?
That's correct.
All right. So you were or you were not injured as a result of this?
Not injured.
All right. So it's not a workers' compensation claim. However, you should definitely go to your union, and your union can deal with your failure, your employer's failure to provide the necessary equipment, tools, or whatever, what have you, as a result of that contract. And they would enter into a representation of you and your fellow workers for that purpose, okay?
Something to make you guys smile. The union is lethargic and lackadaisical. We fight the union to push the issues. They're not really doing it.
It's an unfortunate reality that sometimes unions are not seemingly helpful, and you just have to persist. You have to contact your union rep, whoever that is, over and over again. Bang his door down or bang her door down as much as you can in order to get some help. But they're the ones that need to help you.
Are there law firms that would override the union?
There are, but it would depend. It would depend on your situation. You call me privately or Dean privately, I'm sure we can steer you to the right people.
Yeah, I mean, the bottom line is that you have to assert your administrative obligations under your contract fully before you're able to turn to court. It's another one of those things that the Republicans had their way with the Supreme Court, and they really make it very difficult for union members to bring a claim in court when you have rights under the contract that you failed to assert. So that's the first thing you're going to want to make sure, because otherwise you're not going to be able to bring a claim at all. Lonnie,
we went to court in Harrisburg. We won a major decision. They're still not honoring the decision. It was an arbitrated decision.
Yeah.
That's another reason to go back there.
Yeah, for sure, because if you already have a decision, then that court will have a vested interest in making sure that its decision is followed by all the litigants. And so they don't like that usually, and they'll punish them.
That's called contempt.
Contempt of court. Lonnie, we got to run. Thanks for calling Court Radio. Thanks for being a loyal listener. Have a great Sunday. 215-227-2727. Unfortunately, folks, as is often the case we have more questions than time, Mr. Gross.
But we have phone numbers.
We do. If you've got a legal issue and you need some help with that issue, all you got to do is give us a call at 215-227-2727, and then your legal issues will be resolved.
And I just wanted to thank you, Dean, for having me again as your guest. Love you.
You know, you wouldn't be here unless there was synergy, and it works. Our clients have a common goal, and we want to make sure that their lives are not hurt further by the...
That's why we're here, to help others.
Yeah.
We help you.
There you go.